I want to welcome you to the afternoon session of the conference. I'm Hal Krent. I'm the dean at Chicago-Kent, and we're delighted to have you grappling with these issues. My exposure to tension between technology and privacy arose over 20 years ago when I was asked to defend prisoners who were challenging then this new phenomenon of a DNA data bank. And as with almost all technological advantages, the structure is remarkably similar. There's a new technology. People don't quite understand the limits, what it can be used for. But at the same time, there are privacy overtones. And we've seen in the whole litigation and the expansion of the DNA databases what could happen when there is technology that can be attractive, perhaps like the geolocator software, and then more and more pushes aside concerns for privacy. So I'm simply delighted that you're here to consider this one of the range of tensions between technology and privacy in the geolocator service. And you know, the issue is not that technology is always bad, because technology can be used for good things. In the DNA case, it helped exonerate, ultimately, took a while, exonerate defendants. And of course, there are technologies that give us added protection from snooping and surveillance on the internet as well. So what will happen, of course, with geolocator is the question, and I hope some of the afternoon panel will shed light on that. So with that, Lori Andrews, who's the director of our Center for, one of our directors for our Center for Information Society and Policy. Lori.
Well, I'm just delighted to be able to introduce Professor Jeffrey Rosen of the George Washington University Law School. He's been a commentator on legal affairs for the New Republic since 1992. He's a senior fellow at the Brookings Institute and often appears as a guest on National Public Radio. He writes for The New Yorker and the New York Times Magazine. In fact, the Chicago Tribune called him one of the 10 best magazine journalists in America, and the LA Times called him the nation's most widely read and influential legal commentator. He's written two very well-received books on the judicial system, the Supreme Court, the personalities and rivalries that defined America, and the most democratic branch, how courts serve America. But he's also had a huge impact on the area that we're talking about in this conference as a pioneer in assessing the effects of technology on privacy and liberty. Even in the pre-Facebook, pre-drone era, he was thinking about these issues with his book published in the year 2000, The Unwanted Gaze, The Destruction of Privacy in America. He followed that up in 2004 with The Naked Crowd, Reclaiming Security and Freedom in an Anxious Age. He's also written articles about Fourth Amendment implications of pre-flight screening by the TSA, free speech on the internet, privacy in the internet age, surveillance cameras in Britain, data mining in Silicon Valley, the effects of neuroscience on law, DNA databases, and the future of free speech. Currently, he's working on biographies of Louis Brandeis and William Howard Taft. I'm a personal fan of Jeff Rosen's because he's both a scholar and a writer. You would think the two invariably go together, since academics often write and in great quantity. But few write with the compelling prose and crisp ideas of Jeffrey Rosen. An author is broadly defined as the person who originated or gave existence to something and is responsible for it. Jeff has given existence not only to scores of articles and books, but also to a debate about privacy in the modern age. So now we'll hear from author and public intellectual Jeffrey Rosen.
Lori, thank you so much for that extraordinarily generous introduction. Lori Andrews is one of the most illuminating and thoughtful commentators on the impact of technology on society. I was honored when she invited me to join this conference, and I'm so glad to be here. Thanks also to Helen Kim, who I gather had some role in this invitation. It was wonderful to talk to you at lunch, and thanks to all of you for coming. I'm delighted to be here, and I want to make one big point with three examples and then have a conversation with you about it. The big point is this. Today, lawyers at Facebook and Google have more power over the future of privacy and free speech than any king or president or Supreme Court justice. Law still matters, but the truth is that ultimately, the future of privacy and how much we're tracked in public will be determined more by the decisions of these private corporations than by judicial decisions or legislative acts. And I want to examine with you what that means in three areas. First, the possibility of ubiquitous surveillance and geolocational tracking in public. Second, the difficulty of escaping your past on the internet. And third, the recent controversies over anti-Muhammad videos and the future of free speech. So my first example, geolocational tracking, for me is crystallized in an example that we might call open planet. I was at a conference at Google now several years ago. It was in 2007. And the head of public policy at Google said that he expected within just a few years, Google and Facebook would be asked to put live and online feeds to all the public and private surveillance cameras in the world. So there are already a few apps along these lines. You can log on to Facebook and look at live beach cameras in Mexico, for example. But imagine that the beach cameras in Mexico are linked to the subway cameras in New York, which are linked to the police cameras in London, and all of these feeds are ubiquitous, perhaps even enhanced by roving drones, so the coverage is global, and the images are then archived and stored. Under this system, you could log on to any street in the world, click on a picture of someone, say me, back-click on me to see where I'm coming from, forward-click to see where I'm going after the talk, and basically have the possibility of 24/7 surveillance of everyone at all times. Would this system, first of all, be implemented? Well, Google decided not to engage in linked cameras because it thought that it raised free speech concerns. Let's imagine in a few years, Mark Zuckerberg decides opposite. And he introduces this as this cool new app, check in on your friends and learn stuff and find out things. And he actually makes Open Planet go live. Would it violate the Constitution? In particular, would it violate the Fourth Amendment to the Constitution, which guarantees the right of the people to be secure in our persons, houses, papers, and effects against unreasonable searches and seizures? Well, the first difficulty with a Fourth Amendment challenge to Open Planet is obvious, and that is that Google and Facebook are not the government. The Fourth Amendment only constrains state action. Google and Facebook are private corporations. Therefore, you could argue that there's no constitutional implications of Open Planet at all. All right, well, let's assume, for the sake of argument, that Open Planet is a combination of public and private cameras, some owned by the government and some by the private sector, and that it's being used by CIA agents to track suspected terrorists on the internet. Maybe that would be enough state action to raise some Fourth Amendment concerns. Then, is it an unreasonable search or seizure? Well, we know from the Jones case, which you've already discussed this morning, that the answer under current case law is not clear. If you take Justice Scalia's majority opinion seriously, you'd say no trespass, no Fourth Amendment violation. In Jones, Scalia emphasized the fact that it was important that the police trespassed on private property and physically affixed a device to the bottom of the car to raise a Fourth Amendment concern. Here, Open Planet can surveil us without any physical seizure or trespass at all. Okay, well, let's imagine that the court is guided instead by Justice Alito's concurring opinion, which may well have 5 votes because Justice Sotomayor signaled a willingness to go beyond the trespass rationale that she joined in the Jones case. What then? All right, so Justice Alito says that ubiquitous surveillance that reveals a great deal of information about our geolocational movements may raise privacy concerns. We do have an expectation of privacy in the whole of our movements, said Alito, because that surveillance can reveal so much about us. Our political associations, the bars we visit, our friends and neighbors, all of this is revealed by month-long surveillance, and therefore Alito said, for month-long surveillance, a warrant is presumptively required. For short-term surveillance, it's not. Things might be different when you're investigating serious crimes, signaling a kind of national security exception, and if the police are unsure, they can get a warrant. Okay, well, that sounds like a promising way of constraining Open Planet, but you might say that unlike the case of surveillance in Jones, where the GPS was affixed by the police and there was no claim that the suspect had turned over the information voluntarily. The opposite is the case in Open Planet. The court might hold that I assume the risk, once these drone cameras are ubiquitous, when I'm walking down the street, that my public movements are being revealed under the kind of assumption of risk doctrine, or they might hold even more precisely that I knowingly surrender data about my geolocational movements to the cameras when I walk down the street, and these are stored in third-party servers, and therefore I've abandoned all expectation of privacy in this geolocational data. Justice Sotomayor in Jones said that the court had to reconsider the third-party doctrine because it would have the effect of extinguishing privacy in an age of ubiquitous databases where most of our private data is stored on the digital cloud that is distributed servers owned by Google and Yahoo. Okay, so then we have to confront the challenge of the third-party doctrine. Would that bar recovery for Open Planet? Well, you have some really interesting materials that the organizers have assembled for you, and I read the historical cell site case from the Eastern District of New York written by Judge Garaufis. It was handed down before Jones. It was August 2001. The judge wants to create an exception to the third-party doctrine for cases in which the content of information is communicated to third parties as opposed to header information. This is a very technical distinction, and the truth is the analogy is not perfect. He was relying on cases distinguishing the address on a snail mail letter, for example, which is semi-public and which we don't have an expectation of privacy, from the letter sealed inside the envelope, which supposedly does require a warrant to be opened. And then the next series of cases was that pen registers, which reveal the telephone numbers we call, are not public because we've knowingly surrendered those, but the content of the conversations are considered private. But the analogy doesn't quite work for geolocational data. What's the equivalent of the header information and what's the content? The real question is whether we have an expectation of privacy in our public movements on the street. In other words, whether there's a privacy interest in our public movements, and that can't be solved by old analogies distinguishing between header and content. Really, we run squarely into the weakness of the expectation of privacy test, which is, as we all know, has been criticized as circular. All the government has to do, or all Mark Zuckerberg has to do, is announce tomorrow that Open Planet is going live. It'll be really cool. Just know that all your movements are going to be tracked in public. And according to the expectation of privacy doctrine, our expectations would be reduced in a way that would extinguish constitutional protections. That's why I think that even Justice Alito's concurring opinion in Jones is not firm enough to protect us against Open Planet surveillance. The court really would have to reconsider not only the third-party doctrine, but also the expectation of privacy test. It would have to embrace a version of the normative test, to use the fancy word, that Justice Harlan signaled in the White case from 1971, where Justice Harlan said, it's not right to say that every time I talk to my friend, I have to assume that my friend is broadcasting to the cops. The real question judges have to decide is how much privacy is consistent with freedom in a free and open society. At a certain point, he said, surveillance might make it impossible to live spontaneous lives and to be inconsistent with the security that people expect in a liberal society, and that's something for judges to decide. Until now, American courts have been reluctant to make that highly normative judgment, which gives them a lot of discretion. But without a willingness to do that, I fear that ubiquitous surveillance of geolocational movement may be hard to constrain. There's yet another possibility doctrinally, which is not the Fourth Amendment, but the liberty interest protected by the Due Process Clause. In his opinions in cases involving gay rights and the right to choose abortion, Justice Anthony Kennedy has said, at the heart of liberty is the right to define one's own conception of meaning of the universe and the mystery of human life. Justice Scalia unkindly ridiculed that as the sweet mystery of life passage. But in fact, Kennedy's notion that in a liberal society we need a degree of autonomy against state interference in order to define ourselves is the most natural doctrinal answer to something like Open Planet, and perhaps the most promising way of constraining it. Now, I cannot imagine the same bipartisan coalition that agreed to constrain GPS tracking in Jones agreeing to extend the right of autonomy recognized in Roe v. Wade to stop surveillance in public because of the controversial foundations of the autonomy right. But analytically, it seems to me that may be a surer way of constraining ubiquitous surveillance in public than GPS tracking. All this is to say that the courts will have some role about the future of GPS tracking. I think in the shorter term, legislative solutions may be more promising. There is a GPS bill pending in Congress. You have the text from Senator Wyden. Unfortunately, and this is a political reality, it's not going to pass anytime soon. Even though it's a bipartisan bill sponsored by Senator Wyden, a civil libertarian Democrat, and Josh Chaffetz, a very energetic Utah Tea Party libertarian Republican. Libertarian Republicans and civil libertarian liberals represent a minority of the country, about 20% according to some estimates, and there's really no national majority for these sort of bills to pass. So we've identified a problem without a clear or immediate judicial or legislative solution. And that brings me back to the point I want to stress throughout these three examples. It's the initial decision of the internet service providers to put the cameras up in the first place that may determine the future of privacy, and that's why what Google did is so important, and I hope that Facebook will follow suit. Here's my second example, the right to be forgotten on the internet. And the example I want to begin with is now familiar to many of us because this is the story of a woman who's become a rallying cry. Her name is Stacy Snyder. She, a few years ago, was a 22-year-old teacher in training in Millersburg, Pennsylvania. She put up on MySpace a picture of herself in a pirate's hat. She was drinking from a plastic cup, and she put on the caption, "Drunken Pirate." Her supervisor at the public high school where she was a teacher in training saw this and fired her on the grounds that she was promoting underage drinking. She sued. She said this was legal conduct. It wasn't even clear that she was drinking, and that her MySpace picture was protected speech. A federal judge rejected the claim, saying that the speech was not on a matter of public concern, which is the only kind of speech that is protected for public employees, and therefore was not protected by the First Amendment. And as a result, she never became a teacher. She went into a different field entirely. She's working today in human resources, and her entire career was derailed. Now, we can have different intuitions about the story of Stacy Snyder. Some of us might think that this was a terrible injustice to hold her accountable for this legal off-duty conduct. Others might think that she should be more careful. But the problem faced by Stacy Snyder is faced by millions of citizens around the world in an age when Facebook, having passed the 1 billion member mark yesterday, is responsible for so much of our communication. 1 billion pieces of content shared on Facebook each month. As a result, people are losing jobs, they're not getting hired, they're being fired because of photos and status updates and tweets that they've shared and then regretted. What is the solution to the problem of digital forgetting on the internet? Well, the Europeans have proposed a solution, which was alluded to in the earlier panel, and that is the right to be forgotten. And this comes from a French right called the droit à l'oubli, or the right of oblivion, which is extremely French. It's straight out of Sartre. The French want to be just forgotten entirely. Americans want to be remembered. And the right to be forgotten, as proposed by the European Commission in draft form, is very broad indeed. It would allow anyone to demand the removal of any data relating to them unless it's necessary to serve journalistic, scientific, or literary purposes as determined by a European privacy commissioner. Now, if codified and applied in its current form, this right could sweep very broadly indeed. It would not apply simply to the situation where Stacy Snyder posts an embarrassing picture about herself and takes it down before anyone shares it. Everyone agrees that that is a right that's actually protected by Facebook's current privacy policies, and if that were all the right did, then I don't think anyone would object to it. But the right would also apply in cases where Stacy Snyder posts the picture and then it goes viral, and then she wants to get it down and have it delinked by every search engine in the world. And all of a sudden, we see the free speech implications of this right becoming much more acute. There was a case involving this second category in Argentina, which has codified a version of the right to be forgotten. It involved a pop star called Virginia da Cunha, who had posed for racy pictures of herself, as pop stars sometimes do. They went viral, and then she thought the better of it and wanted to take them down. She demanded that Yahoo and Google delink to the pictures in their search engines. Both search engines said they couldn't do that very easily technologically. An Argentinian judge ordered both search engines to delink the pictures and fined them a lot of money per day. And Yahoo then said, okay, it's just too hard to identify the racy pictures. We are going to remove all references to this woman from our search engine. So if you plug her name into Yahoo Argentina, today you get a blank page and a judicial order saying basically this woman has been deleted pending litigation. Well, I hear some gasps. I mean, the idea that you can literally delete yourself from the internet, remove yourself from public discourse, is not consistent with American notions that truthful but embarrassing information, especially about public figures, cannot be restricted. Imagine all the pop stars who pose for racy pictures of themselves and then want to run for parliament, as pop stars in Italy tend to do. Should you really be able, in the middle of a political campaign, to take all those pictures down, removing possibly relevant information? So we're already seeing a clash between European ideas of dignity and American notions of free speech. But then there's a third category that really the right, broadly applied, could include any nasty status update that any of you posts after the speech. You know, you could say Jeff gave a bad talk and it was really boring, and I could demand that come down, even though it's it's a matter of opinion, but it's embarrassing. And then it would be up to, in the long term, a European privacy commissioner, but in the short term, Google and Yahoo and the internet service provider and Facebook themselves to decide whether your tweet or post was in the public interest, whether it served a journalistic, scientific, or literary purpose. Well, Google and Yahoo and so forth are going to have strong incentives to convert themselves from neutral search engines to censors and substantive editors, because the right to be forgotten as currently implemented threatens to fine them 1% of their annual income, which in the case of Google is $40 billion a year if they refuse a legitimate takedown request. So that's why this strikes me as one of the most interesting and significant privacy and free speech battles of the coming decade. I hope that the European proposal will be narrowed before it's actually codified. There are some amendments that have been introduced but not passed. But regardless, this is, I think, another dramatic example of how law plays a role here. But if the right does pass, it's ultimately the decisions made by those Google and Facebook lawyers on a case-by-case basis about whether or not a particular image is or is not in the public interest that will determine the future of free speech and privacy. That leads to my third example, which sounds both in privacy and free speech, and that's the example most recently of the AntiMuhammad video posted on YouTube, which in September set the Middle East ablaze. After days of rioting in Egypt and Libya, the US government formally requested Google, which owns YouTube, to remove the video. And Google refused to remove the video throughout the world on the grounds that it didn't violate YouTube's hate speech policy, which bans speech that attacks or demeans a religious group, but not a religious prophet or leader. But Google did temporarily block access to this video, the innocence of the Muslims in Libya and Egypt, owing to what Google called the very difficult situation in those countries. There were then speeches at the UN by the presidents of the US and of Egypt setting forth two very different visions of hate speech. President Obama set out the American view, which says that speech can only be banned or restricted when it threatens to provoke imminent violence. The president of Egypt countered with a more European or Islamic view, which says that speech can be banned when it denigrates or demeans the sensibilities or social standing of a group based on religion or ethnicity. But what's so striking about this remarkable incident is that the speeches by the two of the most powerful leaders in the world didn't determine the fate of that video. It was ultimately made by lawyers at Google and YouTube and Facebook and Twitter. And Google and Facebook, in the end, do agree to respect the local laws of countries in which they violated. So after they concluded that the anti-Muhammad video was clearly illegal in a few countries, such as India and Russia, they did IP block the video in Facebook's case, so that if you're a Facebook user signing on from Russia, you couldn't get access to the video, or actually, I guess, block it as well from YouTube in Google's case. But it was Google implementing its own hate speech policy and also making prudential judgments about how much public order was necessary to support that determined the fate of this video. Generally, the internet service providers have adopted European-style definitions of hate speech, but they're enforcing them in the American tradition. In other words, formally they ban speech that attacks or denigrates groups, but these deciders are being quite rigorous about looking for threats of imminent violence before actually reviewing videos. And although they're doing a pretty good job under difficult circumstances, I think more transparency and predictability might serve constitutional values around the world. At this point, I think we need to ask ourselves, who are these people at Google and YouTube who are making these decisions? Now, as it happens, not long ago, I had a chance to meet the woman at Google who was then the free speech adjudicator for the entire globe. Her colleagues called her the decider, because she had the ultimate power to decide whether requests from countries like Egypt and Libya and Turkey would be granted or not. And she was at the top of an interesting pyramid. So the first rung content reviewers at Google are located at YouTube and also at YouTube headquarters in Dublin and India, I think. And these, I got to see these first-order content responders. I went to the YouTube headquarters and was told to look for the people who were reviewing user flags and deciding whether or not videos violated hate speech policies. And everyone in YouTube looked the same. They were 22 years old. They were wearing T-shirts and flip-flops. And they were hunched over laptops. So I couldn't figure out who the content reviewers were. And then my guide said, well, just look a little more closely. You'll be able to tell them by the porn flickering on their laptops. And that's what these young men and women were doing. They're looking at mostly, bless you, at nude pictures and making spot decisions about whether or not they clearly violated policies involving nudity. Sometimes it was more complicated in cases where foreign governments would claim that particular videos violated local laws. And in hard cases where these 22-year-olds were not able to make their own judgments, they would escalate the video up the pyramid and eventually it would reach Nicole Wong. So Nicole Wong told me about how she was woken up in the middle of the night by telephone calls from the Turkish government, which was upset because Greek football fans were posting videos claiming that Muhammad Ataturk, the founder of modern Turkey, Kemal Ataturk, was gay, which he wasn't, but that's illegal to suggest in Turkey. And she doesn't speak Turkish, but she has to decide whether the videos actually do make this claim, in which case they have to come down, whether they're legitimate political satire, in which case she'll leave them up, whether it's a close call, in which case she'll wait for a court order, and meanwhile there's a threat to Google employees on the ground. Well, she eventually decided to remove some of the videos, but only for users with Turkish IP addresses. That wasn't enough for the Turkish government, which feared that someone around the world might be offended by seeing these Greek football fan videos. They demanded a total blocking of them. When Google and Nicole Wong refused, Turkey blocked access to Google and YouTube for years. So this is how free speech and privacy are actually adjudicated. It's not a abstract European law about the right to be forgotten. It is 22-year-olds and the lawyers who supervise them implementing and enforcing their own hate speech policies on the fly in the middle of the night. It's useful, I think, therefore, to parse the policies themselves and recognize the differences among them. And there are interesting differences. The YouTube hate speech policy defines hate speech as speech which attacks or demeans a group based on race or ethnic origin. It's generally okay to criticize a nation, but not okay to make insulting generalizations about people of a particular nationality. That's why Google refused to remove the Innocence of the Muslim video, because it mocked Islam but not the Muslim people. But then Twitter has a more narrow definition of hate speech, which sounds more American. Twitter says, we won't remove anything unless it violates the terms of service, which include a prohibition on direct, specific threats of violence against others. So that's really almost the American definition of unless the speech threatens to provoke imminent violence, it won't be taken down. And Facebook, you might say somewhere in between. It had quite strict rules about hate speech, saying that attacks on people based on their race and ethnicity and so forth have to come down, although legitimate satire is permissible. But Facebook is in the middle, I learned yesterday at a panel, of reconsidering its hate speech policies and narrowing them in interesting ways. They may soon make a public announcement about the degree to which they've altered their policies, but they are thoughtfully moving toward protecting as much speech as possible. Still, there are errors that are made, and I'm going to give you one final example of just how much discretion these lawyers have. During the debate over the construction of an Islamic cultural center not far from Ground Zero, Sarah Palin posted a note on Facebook responding to a statement by Mayor Bloomberg supporting the center. Her note criticized what she classified as extreme views and said a project supported by this cleric should not be approved. In response, some internet commentators reported that Palin's comment had been reported Palin's comment as hate speech and urged others to do so. Facebook deleted the post, and it later released a statement apologizing and claiming the note did not violate our content standards, but was removed by an automated system. In other words, many of the requests never filter up to the 22-year-olds. They're just taken down automatically by algorithms. And this raises important questions of whether due diligence is necessary before platforms like Facebook will remove speech. There are no easy answers to this problem of content review on the internet. Some commentators have called for local bodies in relevant countries to make recommendations to Facebook and Google about what sort of speech to remove, enforcing their own community standards or their own predictions about what speech is likely to cause violence. But this raises a grave problem of a heckler's veto and might protect less speech than the decider model currently does. The decider model may be as good as we're going to get for the moment, but it does rely on a rather unconstitutional notion, not unconstitutional, but a notion which is foreign to our tradition, which is trust the deciders. Trust government is not the constitutional way. We tend to disperse power and create oversight mechanisms. Therefore, it might be helpful for us to think about similar oversight mechanisms, perhaps voluntarily adopted by the internet service providers, that would make it harder for them to play the role of legislator, judge, and executor of their own policies, and instead ensure some transparency and accountability. I have no easy answers to the three examples that I've presented, except to share with you my daily excitement at the privilege of being able to think through the transformation of our free speech and privacy rights in an age when the internet service providers are now the deciders over all of them. Thank you so much for listening, and I would love to have a conversation with you about these fascinating issues. Thank you. Sir.
It sounds like the European proposal also has a decider in it as well.
Yes, the decider there is the more familiar one, the government decider. And although the precise relationship among the various privacy commissioners is not quite clear, and it's not obvious whether each individual country's privacy commission will decide or some new bodies will be set up. But you're absolutely right that there needs to be some decider. And one question is, do we trust government more or the internet service providers more or some mix of the two? What standards are governing the deciders? What sort of transparency guides them? And also, who are these people? I mean, that's an important question. You know, these 22-year-olds are smart and energetic and very hostile to censorship, so they'll probably protect a lot of speech, but they have no special training in local cultures. The European privacy commissioners, by contrast, tend to be very abstract in their dignitary notions and willing to remove a great deal more. There are strengths and weaknesses to each model, but I thank you for reminding us that there's not going to be any system which doesn't have a decider. The question is, who will it be and what standards will guide them? Thank you for that. Do you want your quick follow-up?
I'm sorry.
Yeah.
So you said there has to, basically it sounds like you're saying there has to be a decider, and I wonder if I really would agree with that, whether there has to be a decider as an individual, as a body, as a government official. Do we really have to say there has to be a decider?
Well, we have laws on the books, and Google and Facebook have pledged to respect the law. So they do not take the position that if speech is clearly illegal in a particular country, they can leave it up. Yahoo tried to do that for a while. They said information shall be free, and we're not going to obey local laws. And France said, oh yeah, if you don't remove that Holocaust denial material, that was on eBay. eBay said we don't have to obey French law, and a French judge said, yes, you do. You're going to be fined a lot of money every day. So given the need to respect local laws, someone has to decide when local laws are being violated. And in addition, Google and Yahoo have chosen, as a matter of community standards, to go beyond local laws and to ban speech that they think violates their community norms. So there does have to be some decider there. Now, you could have the people decide, and that's one model, is just to have user flags, but then you need a decider on whether the user flags are legitimate, and then you could have a kind of Wikipedia system where little expert or little localized bodies of users, maybe who appoint themselves, couldn't be the deciders. It would be a kind of wiki democracy decider model. I'm not. I think I prefer Nicole Wong, actually, but the group may disagree.
To the extent that we say agree that maybe the private decider model is appropriate, why not regulate it like we do other private occupations like law and medicine?
Good question, and we could. I mean, that's in a sense what the Europeans are trying to do. They're regulating with a vengeance, and they're not at all taking the position that Google and Yahoo should be free to do what they want, which is to leave up whatever speech is not clearly illegal. They want to create a very sweeping dignitary regulation. You could go beyond that. Google is now being investigated for antitrust violations. We don't know what the Federal Trade Commission will do, but the Commission has the option of remedies, including breaking up Google, separating its search engine from its other features on the grounds that the concentration of power creates incentives to skew the search results in a way that they're not neutral. That would be another form of regulation. Now, Google, fascinatingly, has a response, which is that all of its search algorithms are protected speech. And therefore are immune from regulation because they're protected by the First Amendment. If this defense were pressed, then any regulation of Google would violate the First Amendment. So you're quite right that there's a whole range of regulations that could be imposed from the administrative to statutory. The companies will resist these in various ways, and there are strong speech arguments on both sides. So things get interesting and complicated. Yes, sir.
I'm struck with this 22-year-olds making decisions concept. I don't know if it's a valid analogy, but you have a new industry coming out and just exploding way too fast for everything to keep up. I'm brought back to like Idaho Falls in 1961 when the first nuclear breeder reactor here had a meltdown. Nobody knew about it for many, many years. And replaced by a confluence of factors was being overseen by 3 generic workers who didn't know a thing about nuclear energy or anything like that. And the fallout basically was that the people who came in to try and rectify the situation all got contaminated. They all eventually died. Now this situation strikes me as you could have these 22-year-olds ignoring the situation and the world blows up on an informational basis because of all this outrage in the Middle East or whatever. It seems to be almost a parallel.
It's a very good parallel. I think it's a very good parallel. 2 unregulated industries, as you said. The overseers don't have much experience, and the stakes are life and death, which they are in the YouTube case. The deciders in the past couple of weeks at Facebook understood that the decisions they were making in the name of free speech might lead people to die. And indeed, after Facebook refused to take down the AntiMuhammad video, except in a few countries where it was clearly illegal, there were threats posted on Facebook threatening individual American ambassadors by name. And then the deciders had to decide, should those come down? And initially, they didn't satisfy the requirement that the threats had to be credible, as well as specifying a time, place, and manner. But that was so uncomfortable that they eventually changed the policy and said that ambassadors, like police officers and other especially vulnerable and presidential candidates, cannot be threatened even without specific evidence of imminence. So that's the degree to which these policies are being made up on the fly to some degree. And what's so striking, this has all been created in the past couple of years. Most of these companies began with one young hire coming in and just literally making up the policy and then bringing in more people to formalize it and so forth. So I think your analogy is excellent. And the question is, what do we do about that? And even if you're inclined to leave the decider's ultimate authority, I think certainly a degree of transparency might help us exercise oversight, knowing who the 22-year-olds are, what policies they're applying, some method of appeal. It's complicated by the fact we're talking, a billion Facebook users. You're not going to get full due process and a full range of appeals on every decision. But the analogy is good, and we need to translate into this new field the kind of oversight mechanisms that used to exist in the governmental field. Thank you for that. Yes. Yeah. Sure.
I'm interested in what you call the planet, the camera.
Open Planet, whatever. Make up some silly name.
Okay, Open Planet. In a neighborhood near my house, I guess there's like a 4-mile grid of surveillance systems that the sheriff's department uses to monitor for shootings and other things. But there's a control center that the sheriff's department has where they can watch, but I don't have access to that stream. So this idea of this open planet seems at least a little more democratic than, our own people watching us.
That's a great observation, and it's a very deep one in surveillance technology. You're absolutely right. The objection to the initial range of closed-circuit television cameras, by nature, because they were closed-circuit, access to them was one-sided, which gave the watchers all the power. So I'm sensitive to this. I went over right before 9/11 to write an article about the surveillance cameras in London, which has more cameras per person than anywhere else in the world, and sat in the control room in the digital city of Hull and watched the watchers watch the streets. And what do you think a bunch of bored, unsupervised guys do when they're sitting from midnight to 6 in the morning? They were leering at pretty women. It's like, oh, look at her over there. You're going to have to write an article about how restrained the British are, and then making comments about minority young men who look different and so forth. So that danger of voyeurism and discrimination is very acute when only the state has access to the cameras. And you're absolutely right that element of the problem is remedied to some degree when citizens can watch each other. Now, it's not perfect symmetry. The real transparency advocates say that we should have the ability to watch the state as much as the state can watch us, and that's not the case with Open Planet. I guess it would make it easier to film police encounters than we can now, but there might still be situations where the state had a monopoly on the cameras. The police, for example, refusing audio recording of individual encounters, them recording us, but us not recording them. So people like David Brin have said the real solution then is to accept the ubiquity of cameras, but give everyone access to each other's cameras so that we can watch the state as much as the state can watch us. I agree with you that remedies the imbalance of power problem, but as a privacy advocate, I think it creates a grave other problem, which is the indignity of living in a ubiquitously surveilled society where we have no backstage areas where we can retreat from common gaze. And I think it's a grave threat to individuality and freedom to be constantly surveilled and to live in glass houses, even if everyone has access to everyone else's camera. So that's why I'm not a transparency advocate to that degree. But you raise an important point to say that to the degree that these cameras are going to proliferate, whether we like it or not, one way of proceeding would be at least to ensure equal access. It's absolutely, and the degree to which drones will change the equation makes it all the more frightening, because you could imagine the state monopoly on power would become far more troubling when the state has the ability to send a drone to surveil any particular individual, and the individual has no ability to fight back. We're at such a ground zero in respect to the legal regulation of all this. It's still not clear whether simply recording an encounter with the police is legal. It varies from state to state. Many states allow the video recording but not the audio recording under state wiretap laws. Some courts are finding that asymmetry unfair and saying if the police can record you, you can record the police back. The drones, as you discussed this morning, are unregulated because of uncertainty about whether they're even covered by the Federal Aviation Administration if they're flying low. So all of this is going to have to be imagined from the ground up, and that's why this subject is so great. Yes, sir.
To some extent, don't the popular media also play a similar gatekeeping role? And to the extent that they do you think that what's happened with the way the popular media acts as a gatekeeper is at all instructive for what we're discussing here?
Interesting.
I mean, you have editors, you have attorneys, the same thing going on at newspapers, TV stations, news stations. They reach a lot of people. They have a lot of impact. It's not quite the same thing, but
I think you're absolutely right. It's a great analogy. And at their best, editors at great newspapers and magazines like the New York Times ensure the kind of thoughtful balancing of interests that the Google deciders are trying to do too, deciding to publish some aspects of WikiLeaks but not all of them, for example, which is what the New York Times did. The problem is that those gatekeepers are under siege by technology. You know, at WikiLeaks, where anyone can engage in document dumps that can circumvent editors, is one where that balancing role is under siege. So I think that's a good note on which to end, which is to say that the deciders may have whatever problems they do, but even they may find it difficult to keep their editing function alive in a world where technology is making it possible to circumvent them.
Now, we have a break till 2:45 to reconvene, but let's thank Jeff Rosen for a wonderful presentation.
Thank you very much. It's a great conversation. Thank you for inviting me.